Good evening. This is Ching reporting from Paglat, Maguindano with spokesperson Dillera from the International Court of Justice to help us understand the opinion given by the court on the issue. Before we go to spokesperson Dillera, here is a short video that would help us understand the impact of a nuclear war.
70 years ago, the nuclear bombs dropped over Hiroshima and Nagasaki exploded and to this day remain the only use of nuclear weapons for warfare. But with around 15,000 warheads remaining in the world, what happens if we have a nuclear war? The impact of a single nuclear bomb depends on many factors like the weather, weapon design, geographical layout of where the bomb hits, and if it explodes in the air or on the ground. Approximately 35% of the energy comes in the form of thermal radiation or heat. Since thermal radiation travels at approximately the speed of light, the flash of light and the heat come several seconds before the blast wave, and this causes flash blindness to anyone looking, a temporary blindness of a few minutes. With a 1 megaton bomb, which is 80 times larger than the Hiroshima bomb, but much smaller than many modern nuclear weapons, those 21 kilometers away would experience flash blindness on a clear day, and even up to 85 kilometers away on a clear night. Thermal radiation burns happen closer to the bomb, with first-degree burns occurring around 11 kilometers, second-degree burns at 10 kilometers, and third-degree burns destroying skin tissue at 8 kilometers. Third-degree burns that cover over 24% of the body will likely be fatal without quick medical care. These distances are variable depending on the weather and what clothing you're wearing. White clothing, for example, can reflect some of the energy, while darker clothes absorb it. At its center, the Hiroshima explosion was estimated to be 300,000 degrees Celsius, which is over 300 times hotter than the temperature bodies are cremated at. This intense heat reduces a body to its basic elements. The radiation from the blast also behaves like sunlight, so objects cast shadows where the radiation doesn't directly hit. But most of the energy released in a nuclear explosion is in the blast, which drives air away from the site of the explosion, creating a sudden change in air pressure that can crush objects or knock them down. If we use a 1 megaton bomb as an example again, within a 6-kilometer radius, there would be an estimated 180 tons of force on the wall of every 2-story building, with wind speeds of 255 kilometers an hour. Within a 1-kilometer radius, the peak pressure is 4 times greater, and wind speeds reach 756 kilometers an hour. The human body can endure this amount of pressure, however, the winds would create fatal collisions with nearby objects, so deaths would largely be from collapsed buildings. All this at 1 megaton. Compare that with the largest nuclear bomb ever detonated, the 50 megaton Tsar Bomba dropped on an isolated island in Russia, and you're looking at 3,333 Hiroshima bombs combined.
Here's a brief background or summary of the events leading to the opinion. On December 15, 1994, the United Nations General Assembly adopted a resolution to submit to the International Court of Justice for advisory opinion. The following question: is the threat or use of nuclear weapons in any circumstance permitted under international law? On December 19, 1994, the Secretary General of the United Nations officially communicated to the registry the decision taken by the General Assembly as stated in their resolution. On January 6, 1995, the letter was filed in the registry. 28 states filed their written statements, and on October and November 1996, 22 states presented oral arguments in the course of the oral proceedings. On July 8, 1996, the court rendered its advisory opinion. The court handed down its advisory opinion on the request made by the General Assembly of the United Nations on the question concerning the legality of the threat or use of nuclear weapons. The final paragraph of the opinion reads as follows: for the reasons the court, by 13 votes to 1, decided to comply with the request for an advisory opinion. And they also replied in the following manner on the question put by the General Assembly. They voted unanimously that there is neither customary nor conventional international law any specific authorization of the threat or of use of nuclear weapons. By 11 votes to 3, they said that the opinion that there is neither customary nor conventional international law any comprehensive and universal prohibition of the threat or use of nuclear weapons as such. They also voted unanimously on the opinion that a threat or use of force by means of nuclear weapon that is contrary to Article 2, Paragraph 4 of the Charter of the United Nations and that fails to meet all the requirements of Article 51 is unlawful. They voted unanimously on the opinion a threat or use of nuclear weapons should also be compatible with the requirements of the international law applicable in armed conflict, particularly those of the principles and rules of international humanitarian law, as well as the specific obligations under treaties and other undertakings which expressly deal with nuclear weapons. And by 7 votes to 7, by the president's casting vote on the opinion, it follows from the above mentioned requirements that the threat or use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict and in particular the principles and rules of humanitarian law. However, in view of the current state of international law and of the elements of facts at its disposal, the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self defense in which the very survival of a state would be at stake. They also voted unanimously on the opinion that there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. So, spokesperson Dillera, on the question of jurisdiction, can you give us some opinion given by the International Court of Justice?
The International Court of Justice draws its competence in respect to advisory opinion from Article 65 of Statute of the International Court of Justice, which provides that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such a request.
How about on the issue that such question is a legal question and not a political one?
Oh, okay. Well, the court observes that it has already had occasion to indicate that questions framed in terms of law and raising problems of international law are by their very nature susceptible of a reply based on law, and those which appear to be questions of a legal character. Such is actually discussed under the advisory opinion of the International Court of Justice on Western Sahara.
May I ask if does the court have the discretion to give an advisory opinion?
Well, Article 65 of Statute of the International Court of Justice, which provides that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such a request. So the statutes actually leave discretion as to whether or not it will give an advisory opinion that has been requested of it once it has established its competence to do so.
So, from the questions being raised by the member states, uh, what is the opinion of the court on the issue pertaining to the formulation of the questions posed?
Well, the court finds it unnecessary to pronounce on the possible divergences between the English and French texts of the questions put. Its real objective is clear: to determine the legality or illegality of the threat or use of nuclear weapons.
So, on giving this opinion, uh, what is the applicable law on the issue?
Well, the court concludes that the most directly relevant applicable law governing the question of which it was seized is that relating to the use of force enshrined in the Charter of the United Nations and the law applicable in armed conflict, which regulates the conduct of hostilities, together with any specific treaties on nuclear weapons that the court might determine to be relevant. The court said it is imperative for it to take account of the unique characteristics of nuclear weapons, and in particular their destructive capacity, their capacity to cause untold human suffering, and their ability to cause damage to generations to come. Article 2, Paragraph 4 of the Charter, the use of force against the territorial integrity or political independence of another state or in any other manner inconsistent with the purpose of the United Nations is prohibited. So in Article 51, the Charter recognizes the inherent right of individual or collective self-defense if an armed attack occurs. A further lawful use of force is envisaged in Article 42, whereby the Security Council may take military enforcement measures in conformity with Chapter 7 of the Charter. The entitlement to resort to self-defense under Article 51 is subject to the conditions of necessity and proportionality.
What is the opinion of the International Court of Justice on the rules on the lawfulness or unlawfulness of nuclear weapons as such?
Well, the court first addresses the question whether there are specific rules in international law regulating the legality or illegality of recourse to nuclear weapons. There is no specific provision that prohibits or authorizes the threat or use of nuclear weapons or any other weapon in general or in certain circumstances. Their emergence as lex lata or a customary rule specifically prohibiting the use of nuclear weapons as such is hampered by the continuing tensions between the nascent opinio juris on the one hand and the still strong adherence to the doctrine of deterrence, in which the right to use those weapons in the exercise of the right to self-defense against an armed attack threatening the vital security interests of the state is reserved on the other. So I hope that answers the question.
Thank you very much. Can you tell us how the International Court of Justice uh, can see or can demonstrate the application of the international humanitarian law on this specific issue?
So, not having found a conventional rule of general scope nor a customary rule specifically prescribing the threat or use of nuclear weapons per se, the court then deals with the question whether recourse to nuclear weapons must be considered as illegal in the light of the principles and rules of international humanitarian law applicable in armed conflict and of the law of neutrality. The court observes that the cardinal principles contained in the texts constituting the fabric of humanitarian law are the following. The first is aimed at the protection of the civilian population and civilian objects and establishes the distinction between combatants and non-combatants. State States must never make civilians the object of attack and must consequently never use weapons that are incapable of distinguishing between civilian and military targets. It is also prohibited to cause unnecessary suffering to combatants. It is accordingly prohibited to use weapons causing them such harm or aggravating their suffering. So states do not have unlimited freedom of choice of means in the weapons they use. The court also refers to the Martens Clause, a modern version of the clause, excuse me, is to be found in Article 1, Paragraph 2 of Additional Protocol 1 of 1977, which reads as follows. In cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principles of international law derived from established custom, from the principles of humanity, and from the dictates of public conscience. The court notes that the nuclear weapons were invented after most of the principles and rules of humanitarian law applicable in armed conflict had already come into existence. The conferences of 1949 and 1974 to 1977 left these weapons aside, and there is a qualitative as well as quantitative difference between nuclear weapons and all conventional arms. However, in the court's view, it cannot be concluded from this that the established principles and rules of humanitarian law applicable in armed conflict did not apply to nuclear weapons.
Thank you. And how about the principle of neutrality?
Well, the court finds that, as in the case of the principles of humanitarian law applicable in armed conflict, international law leaves no doubt that the principle of neutrality, whatever its content, which is of a fundamental character similar to that of the humanitarian principles and rules, is applicable. Well, subject to the relevant provisions of the Charter of the United Nations. So it is applicable to all international armed conflict, whatever type of weapons might be used.
That's a wonderful explanation. So, uh, what are the what are the conclusions that is to be drawn from the applicability of international humanitarian law and the principle of neutrality?
Well, the court is led to observe that it cannot reach a definitive conclusion as to the legality or illegality of the use of nuclear weapons by a state in an extreme circumstance of self-defense, in which its very survival would be at stake. So the court appreciates the full importance of the recognition by Article 6 of the treaty of the non-proliferation of nuclear weapons, of an obligation to negotiate in good faith a nuclear disarmament. So the legal import of that obligation goes beyond that of a mere obligation of conduct. The obligation involved here is an obligation to achieve a precise result nuclear disarmament in all its aspects by adopting a particular course of conduct, namely the pursuit of negotiations on the matter in good faith. So this twofold obligation to pursue and to conclude negotiations formally concerns the 182 state parties to the treaty on the non-proliferation of nuclear weapons, or the vast majority of the international community. Indeed, any realistic search for general and complete the disarmament, especially nuclear disarmament, necessitates the cooperation of all states.
That's it for spokesperson Dillera. Thank you very much. Uh, the court finally emphasizes that its reply to the question put to it by the General Assembly rests on the totality of legal grounds set forth by the court, each of which is to be read in the light of the others. Some of these grounds are not such as to form the object of formal conclusion in the final paragraph of the opinion. They nevertheless retain, in the view of the court, all their importance. And adding to that is a line from a Spider-Man movie that says, "With great power comes great responsibility." All states should be reminded of the responsibility that is inherent with the power that they possess. Thank you very much and good evening.